Another exciting episode here on the Professional Edge. My name's Sean Todd, tax attorney, certified financial planner. What we're talking about is beyond the will, comprehensive estate planning for our listeners here. So when we talk about your estate plan, most of us remember that we talk about a will, obviously. And if you don't have a will, then you're going to go to the law of descent and distribution in your state, and the state in which you're domiciled is going to settle your estate for you. Now, we all know that that's probably not going to be the best solution. So therefore, a lot of people default and go to this last will and testament and go ahead and sign that and be done. Well, what happens if something happens to you and you don't pass away? Well, part of your comprehensive estate planning, you should have a durable financial power of attorney. That's going to allow your agent to come in and make some financial decisions when you are mentally incompetent to make your own decisions. Could be a head trauma, could be a stroke, things like that. Or actually, that's called a springing power of attorney. Or we can have an immediate power of attorney, which says upon your signature, your agent, whoever that might be, can make your financial decisions. We don't need to get two doctors say that you're certified to be mentally incompetent. So there are two types. One is an immediate power of attorney and one is a springing power of attorney. So depending on your circumstance will dictate which one's going to be the best for you. So that's going beyond the will, your comprehensive planning. And of course, you would want to consider your advanced healthcare directive. Who is going to make your healthcare decisions when you cannot make your own decisions? So with that in mind, we always try and have a primary and then two alternates. So primary might be the spouse, and then the two alternates might be a child, and then the second child, or it might be a close friend if you don't have children. So therefore, that's going to be beyond the will. We got to take into account if something happens to you and you don't pass away, but you're mentally incompetent, somebody's got to step in. And if we don't have this in place, what's the alternative? Well, guess what? The decision maker who wants to take over that task, and I'm going to tell you they won't do it very willingly, but they will do it. Then we have to file a petition to the probate court to have them appointed. You know what? It's an expensive and timely process, but we're going to do it in order to have the authority to make those financial decisions if you do not have that durable financial power of attorney. What's the other way that we do? Well, beyond the will, comprehensive estate planning. I hear this all the time. I'm getting ready to go in the hospital. In case something happens, I'm going to add my daughter to my bank account. Okay. Is that a signatory on the account or is that on the account title? They're like, does it matter? Yes, it does matter, because when we do our planning beyond the will and we do your comprehensive estate planning, well, there is a significant difference between adding them as a signatory on the account versus adding them to the account. Well, let's go through the first one. You add them to the account. Their name is now on that account. If something happens to you and you pass away, the person you added to that account can walk into the bank and just take the money. It doesn't matter what your will says and says split it equally between my three kids. Who's ever on that account legally is entitled to the account. And I will tell you, money changes people. I've done over 3,000 estate plans, and there is at no time any surprises in the distribution of assets from an estate. I've seen it, I've experienced it, and I just shake my head. I can't judge. That's not my duty. My duty is to execute the wishes of the decedent and go according to what the law says. Now, that child who is on that account can always say, no, that was mom's desire just to cover things when she went into the hospital. I understand her wishes is to divide this account three ways. That's what I'm going to do. But I'm here to tell you, by the operation of law, the way that account title is titled, that child has no legal responsibility to share that with the other two siblings. Let that sink in for a second. So what if we just add them as a signatory on the account? and then mom passes away. Well, there we go. Now we're going to default to the terms of the will. Signatory authority ends, and they are not, quote, on title to that account. So therefore, that account would be controlled by the estate. The estate is now controlled by the distribution terms inside the will, and therefore the kids are going to share it equally no matter what. So keep that in mind. But my real concern is if you're going to add your child to that account, let's do it one step further, because if you add the child to the account, you just subject that child's potential creditors to their claims. So what if your child's getting or going through a divorce right now and you're getting ready to go in the hospital and you add their name to that account? You know what? A half-baked lawyer is going to say, let me see all the bank accounts in which you are on title. Guess what? Just happened. They have to show this account. Even though this is mom's account, they were added on title, and the lawyer's going to say, you know what, we need to include this $200,000 in mom's bank account as part of the divorce account. And you raise your hand and say, well, no, this is mom's account. And the attorney's going to say, well, you know what? You're on that account. You have the ability to take those assets for your own benefit. Those are part of the marital estate now. So let's go beyond the will and do some comprehensive estate planning. These are just simple things that each of our listeners here on the Professional Edge should take into consideration. And yes, I'm sure you don't drive around trying to plan your estate in your car, or when you're listening to the podcast called The Professional Edge, you don't do your estate planning and all these gotchas. Well, that's where you're going to delegate that task to think about these things and put them in place, and think beyond a will and do your comprehensive estate planning. We've done 3,000 of these, and if you want that experience on your side in planning your estate, give our office a call, 877-654-9798. That number again, 877-654-9798. Be sure to go to our website. That is Echo Mary Charlie, emcadvisors.com, Echo Mary Charlie advisors.com, that's plural, and go and request your ultimate estate planning guide, and that will get you thinking in the right direction, meaning A, should I leave my assets outright to my surviving spouse? Surviving spouse is looking at you right now if you're listening and go, yeah, you should. And I will be like, maybe not. And here's why. Because if that surviving spouse gets remarried and they have an I love you will, where's your assets going? The first one to pass away. Well, went to the surviving spouse and they signed a new I love you will and they pass away. Well, that new I love you will is going to H2, and that's not a Hummer. That's the husband number 2 or W2. Not W240 like WD40, but W2. That's wife number 2. And therefore, there is going to be a complete disinheritance of the children of that first marriage. Now, look at each other in the eye and just say, ooh, is that what we really want? Is the temptation or the distraction of potentially disinheriting our own kids? It's probably not what you want. What you want is to have the surviving spouse to be okay, protected, have access to all of these assets that you've accumulated during the marriage. But if they should get remarried, let's not allow that surviving spouse the ability to leave all the assets of the estate to that new spouse that they got married. And again, longevity. We're seeing marriages when people are in their 60s and 70s. They're getting remarried. They want that companionship and they want to show their commitment. And yes, they've been a widow or widower for a decade plus, and now they find this companion that they get along with, and lo and behold, they're from the old school. They're going to get married before they move in together. Okay, that's great. But let's just go beyond the will, do some comprehensive planning, and protect our children of that first marriage to make sure they cannot be completely disinherited. So that's where that testamentary trust comes up in play. And that's going beyond the will. You can still leave everything to the surviving spouse, but we're going to dictate where it goes in that testamentary trust. So how else can we go beyond the will for comprehensive estate planning? Well, you know what? Your largest financial asset might be your 401k or your IRA. And I bet you, as a listener here on the Professional Edge, you may or not be able to locate that document which designates who your primary beneficiary is going to be. Think that, put that on your to-do list. Find that document. But number two, when you named that, guess what? You probably named your spouse as being the primary beneficiary, and then on the second line for the contingent beneficiary, you put your kids' names down. Well, that's all well and good. You know what's going to happen, or the potential is going to happen? You pass away, your largest financial asset is going to be controlled by that simple primary beneficiary designation. That goes to your spouse. Your spouse rolls it over into their IRA, and they get remarried. Who's on that primary beneficiary line? Guess what? It's H2 or W2. It happens all the time. I'm telling you, as a tax attorney who's done 3,000 plus estate plans, we see this all the time. That second spouse comes in and is the primary beneficiary on that large 401k that got rolled into an IRA, which then named the surviving spouse to be the primary trustee. Boom. They transferred over to Merrill Lynch, Vanguard, Fidelity. It doesn't matter where it goes to. But the default provision is to name the spouse as being the primary beneficiary on that document. That's where you've got to go beyond the will. Do your comprehensive estate planning to double check where that is, because you know what? The beneficiary designation on that IRA account supersedes whatever you have in your estate planning document. Let me say that one more time. It is significant. The terms in the beneficiary designation on your IRA or your 401k supersedes whatever you have in your estate planning documents. Again, that one line item could control the disposition of the largest financial asset you have in your possession. So if that's not properly coordinated, you can also disinherit your kids from that 401k. So if that's not enough to wake you up, and give our office a call at 877-654-9798. That number again, 877-654-9798. Then I just wish you the best of luck on that. So thanks for listening to Beyond the Will, Comprehensive Estate Planning. My name's Sean Todd, tax attorney, CPA, and certified financial planner, host here on the Professional Edge for north of 5 years, and I appreciate you listening in today.
With today's financial markets, are you getting the personal and professional attention you and your money deserve? Clients of estate management counselors benefit from having one set of professionals advise them on their tax, estate planning, and investment advice. We call that the Professional Edge. Sean Todd is a tax attorney, CPA, and certified financial planner. With over 15 years' experience, he welcomes the opportunity to assist you in preparing for retirement, implement effective tax planning strategies, and to help you properly plan your estate. His radio show, The Professional Edge, is aired weekly on Sundays at 9 a.m. If you're interested in meeting with Sean, call his office at 877-654-9798. That's 877-654-9798. Do you want to feel more confident about making the right investment, tax, and estate planning decisions? Today, these decisions are more complex than ever. Have you thought about working with a professional advisor and not sure who to turn to? Not sure what qualifies one to be an advisor? Sean Todd is more than qualified as a tax attorney, CPA, and certified financial planner. Sean is with Estate Management Counselors. Estate Management Counselors operates as an independent fee-only investment advisory firm. They're dedicated to gaining a personal understanding of their clients' objectives and implementing professional counsel and advice to achieve those objectives. So take a second to talk with Sean Todd to learn how you can benefit from their multidisciplinary practice where they coordinate their clients' legal, tax, and investment strategies into one comprehensive and integrated plan to enhance and protect their clients' financial security. You can reach Estate Management Counselors and speak with Sean Todd by calling 1-877-654-9798. That's 1-877-654-9798.